Thank you. Well, everything's possible. Congratulations for those of you who stayed the course and are still with us. My duties are to say as little as possible, but to enforce this time limit with rigor, which I will try to do. And unlike the previous chairman, I haven't done lots of research on on the panelists here, so I can't tell you anything about them at all, and anything they want you to know, they will have to tell you themselves. I've been much impressed, with only one or two exceptions, with the discipline shown by previous panelists, adhering to the very unreasonable time limit that has been imposed on us all today. Coming as I do from a forensic tradition which does not impose time limits, I'm going to give you a useless fact followed by an acute observation. A contemporary of mine from university who practiced at the commercial bar and was involved in a case which those of you who are commercial lawyers may well know, a case against the Bank of England following the collapse of the International Bank of Commerce and Credit International. And he appeared for the Bank of England. His closing speech in that case lasted 119 days, which is 6 months of court time, and is a record which has not been surpassed. That's the useless fact. He then became a High Court judge himself and hated it and was hopeless. And the moral of the story, it may be that not being able to speak proved too much to bear, but the moral of the story is that not even some of the most successful lawyers make awful judges. And some of the poorest practicing lawyers make gifted judges. So make of that what you will. Now, it is with much pleasure that I invite Judge Plavšić from Serbia to address you.
Thank you, Chair.
I'm going to use my phone.
We discussed 12
we
minutes.
did, yes.
12 minutes.
Well, we didn't.
No, I will speak very fast in order to say everything that I wanted to say. So, dear colleagues, it is really my great pleasure to be here today and to share my experiences about the topic that is professionally, personally, as being a judge of the Constitutional Court, very important to me, about ethics, independence, and accountability of the Constitutional Court judges. And whenever we talk about accountability and ethics, judicial ethics, we usually think about trial judges and career judges. However, me being a Constitutional Court judge, when I joined the court, I understood that our ethics and our accountability is a little bit different than the career judges. So in my presentation, I will try to explain it. And I will focus on several questions. What all judges have in common, very shortly. And then I will try to explain what do ethics and accountability mean for the Constitutional Court judges and what separates us from the career judges. And then I will say a few things about Serbian experience, and I will try to conclude, to come to some kind of conclusions and recommendations how to reform the system. Judicial ethics, and it was mentioned in previous panels, is about the behavior of judges, both in their decision-making role, but also outside of it. It is about behavior that upholds trust, impartiality, integrity, and independence of the judiciary, big words. Accountability, on the other hand, represents a mechanism by which judges are responsible and accountable for their conduct. And we already heard what all judges, including Constitutional Court judges, have in common. That is to be independent, impartial, and act with integrity. They also must disclose their interest, avoid conflict of interest, and to give clear, reasoned decision. Very importantly, all judges must be subject to some kind of responsibility regime. Disciplinary rules, standards of conduct, and codes of ethics exist not to punish judges for their unpopular legal views, but to protect the institutions and office from corruption, abuse of powers, and serious misconduct. However, for Constitutional Court judges that operate in a different constitutional environment, these words, independence, ethics, accountability, mean something more demanding and often very challenging. Why are we so different? There are several structural elements that makes us different from our colleagues in the judiciary. First, the mandate and status. We are not career judges. We are not promoted, evaluated, transferred, or ranked within the judiciary hierarchy. Constitutional Court judges typically have one long, fixed, very often non-renewable term of office. The Constitutional Court itself is not on the topic of the judiciary system. We are more of a special constitutional body and special branch of power. We like to think of ourselves as a fourth branch of power. And this means that all classical tools of internal judicial accountability, evaluation, promotion, disciplinary procedures simply do not apply to our situation. Our responsibility is designed ex ante with our appointment procedure and also ex post with the exceptional cases of our removal. Second structural element that is different is the way we are appointed. Unlike most career judges, and this is what we heard in the previous panel, we are usually appointed by political bodies, by parliament, by president, or in mixed systems like in Serbia, by Supreme Courts. I was personally appointed by the Supreme Court, and I think of that situation. I think that it speaks very, very modestly speaks about my career, and this itself is not essentially problematic, but it carries a risk of politicization, favorism, if not regulated by very transparent and strict rules. When there is a possibility for new terms of office and reappointment, that can create some kind of issues about the independence and impartiality of the judges. Third structural element is the nature of our jurisdiction. We rule on the constitutionality of general laws, on laws and other general acts. We decide on the electoral disputes. We also decide on the conflict of competence between branches of power, and we also very often decide on the individual human rights. The impact of our decision is very often systemic. They have erga omnes effect, and they very often trigger legal reforms. Our decisions very often have deep political, social, and institutional consequences. So the ethical question is not whether a judge behaved respectfully and complied the procedural rules. The ethical, deeper question is, did the judge, Constitutional Court judge, preserve constitutional commitment and institutional integrity under the intense, visible or invisible pressure that comes? And this raises delicate expectations of independence and ethical conduct. Fourth is the environment in which we work. And we usually function in the intersection of the law and politics. Even when we are strictly impartial, our decision very often can be read politically. We face media campaigns, public criticism, expectations from political actors, and sometimes informal pressure. Public expectations are high. Constitutional Court judges are and should be a symbol of rule of law. Our academic work, public statements, social contacts, and even our post-mandate careers are feed into perception of our behavior. In this environment, Constitutional Court judges cannot rely automatically on the same ethical and disciplinary models designed for career judges. We need more tailored approach. The next is the issue of immunity and special status that we have. We often have special functional immunity for our decision and also special incompatibility rules that prohibits any political functions. So what are the ethical and accountability challenges for the Constitutional Court judges? We heard in the previous panels that accountability, independence are not opposite, and they have to be in some kind of a balance, and that means that the judges must be free in their reasonings, legal reasonings, but at the same time, judges must be responsible and accountable for the conflict of interest, abuse of power, serious breaches of their duties under clear, transparent, and predictable rules and procedures. For Constitutional Court judges, this balance between independence and accountability is more delicate. Why? Because of the differences that I mentioned, the usual internal career mechanism, accountability mechanism, performance review, disciplinary promotions, and disciplinary procedures do not apply. Our decisions cannot be appealed within the national legal system, and there is internal check that is weaker than in the ordinary courts, and this makes ethical behavior and trust even more important. In addition to this, the temptations from political actors to reward or punish decisions by manipulating appointments, terms, and removal is particularly strong. This is why the criteria and standards for our appointments, our mandate and removal must be not just formally legal, but substantially resilient to political opportunism. Now I will say a few words about Serbian system. in paper, we look very solid and aligned with the European standards. The strengths are that we have pluralistic appointments by president, 5 judges by appointed by president, 5 by the National Assembly, and 5 by the Supreme Court. And this system, mixed system, is aimed to prevent domination by any single political actor. We have strict incompatibility rules, we have functional immunity, and we have limited grounds for dismissal. Our courts decide collectively, and this decision-making protects us from being externally targeted by the media, but it increases internal responsibility. In addition to this, there is an external accountability. Under Serbian law, all judges must declare assets, income, potential conflict of interest, and also outside engagements to the Agency for the Prevention of Corruption. However, there are several issues with the system. First, we do not have a code of ethics. General judicial standards are very helpful, but they are not sufficient. The appointment process is not as transparent as it should be. Public hearings, disclosure of criteria, the open discussion of the candidate's qualification are very limited and leaves too much space for party negotiation behind closed doors. Second, we have fixed 9-year mandate with the possibility for reappointment. Judges then may act to please appointing authorities, and with that, they can compromise impartiality. The management of conflict of interest and recusal is not very visible to the public, and this may undermine the trust, even when decisions are, in fact, very correct. And finally, the court's public communication remains relatively modest. In the age of intense public scrutiny and social media, silence of our court is often misread as indifference or weakness. Clear, accessible explanations of the court's role and legal standings is very important as a part of ethical responsibility. And when you look in the international standards in Strasbourg case law, there are several practical conclusions that could follow that Serbia can use in future reform. First, the court must be lawfully and transparently constituted.
You have 2 more minutes.
Okay, thank you. Appointments procedure should be pluralistic, merit-based, and open to scrutiny. Second, responsibility of Constitutional Court judges must be legal, not moralistic or political, and grounds for removal or other serious measures should be precisely defined in a law. Third, the integrity mechanism can and should be strong, especially in the system with a history of political interference. But these mechanisms must be based on the clear criteria, fair procedure, and individual assessment. And finally, perhaps most important in daily life of the Constitutional Court judge must promote a culture of self-restraint in contacts with political actors, in public appearances, and in accepting external function and in deciding what to do after their mandate ends. Thank you for your attention.
Oh, thank you.
Was it? You were surprised.
Yes.
Thank you.
I had been coerced into according an extra 2 minutes to Judge Plavsic, which she has.
Very happy.
But I can't stop it. She didn't need the full 2 extra minutes. But I have to say, as all administrators do whenever they make a decision, this should not be taken as a precedent, ladies and gentlemen. So for everybody else, it remains 10. And my defence, of course, is the Francis Bacon defence when he was Lord Chancellor a while ago and was charged with corruption. He said, I haven't been corrupt. I've taken bribes from both sides in every case. Right, Professor Jougler, please.
Thank you. And I would like to thank, first of all, the organizing committee for the invitation. I have to admit, I was at first a little bit surprised by the invitation. I was pleased, but surprised because I'm not a judge, and I'm not, to be honest, a specialist of procedural law. But when I saw the topic and I saw it's about accountability and legitimacy of the judge, okay, I said, let's go. Everybody has always something to say about it, and I believe that I do have just 1 or 2 small arguments to propose you about that. It's a very classic topic, but at this time it's a very modern topic. A very modern topic, what do I mean? I mean that, unfortunately, we are living some kind of dark times for democracy in general. We are seeing right now some old or new democracies falling to populism. And at each moment we see that, we are expecting, or maybe I'm just too naive, I'm just too romantic, I don't know, we are expecting the judiciary to step forward and to say, okay, I will be the shield of justice, I will be the guardian of the rule of law, no pasar from the judges. But in truth, in reality, it seldom happens. On the contrary, we see attacks from the populists and against not only intellectualism, but against the judiciary. We see, what do we see? We see the same question ever and ever. Why? Why are you legitimate to judge on me? I am the voice of the people. Where is your legitimacy? So we have to talk about that right now. What exactly is the legitimacy and what is exactly the possibility of accountability of the judges on the judiciary? To start with the concept of legitimacy, we should go back to Weber, in fact. Weber distinguished between three kinds of legitimacy: charismatic, traditional, normal, legal, normative. So with all due respect to the judges, we won't use charismatic of traditional legitimacy here. But what is to remember, it's that the legal normative legitimacy for Weber is based on belief. In other words, it's not a legitimacy per se, it's a concept that people believe that a power should become an authority. That gives somebody the legitimacy to rule, to have power. So power becomes an authority when people believe in this power in a democratic society. So let's keep this concept in mind and use it on judiciary. In this aspect, we could say that judiciary is not a democratic legitimate power, but more, in the true meaning of the word, an aristocratic power. Aristocratic in the sense that we are expecting the judge to say the law, to interpret the law. So it is the ability of the judge to interpret the law that make it legitimate to be a judge. But again, it's not the essence that it matters, but it is the appearance that matters. What the public, in the public scrutiny thing, will understand about it. So to legitimacy to accountability, from legitimacy to accountability, to be very fast, should the judge be accountable? Again, I will steal today a lot of sociologues. I will steal from Foucault. Who will judge the judges? I hope I won't not be too provocative, but I will say nobody. In the strict sense of the term accountability, there should not be any kind of accountability, because an accountability in the sense of external control would undermine the concept of judiciary as independent power. And independence of judiciary is a real pillar, in my mind, of the rule of law. So we should not try to focus on accountability in the legal sense of the word. But nonetheless, let's go back a second to the idea of legitimacy. Legitimacy means public scrutiny. So here is maybe the true accountability of the judge. The principle that the public, in a transparent matter, should have access to the way the judiciary is working. And we arrive to the main part of my presentation. I would like to discuss with you a second the fundamental concept of open justice. For example, in Cyprus, when we are talking about crisis of the judges, crisis of the legal system, always we are thinking about enforcement or efficiency. There are two real problems. But in the moment of crisis of our modern democracy, I think that we should focus more on the problem of open justice. Open justice is a very principle in common law countries. It's well known, it's a little bit known in on continental law countries. It's an umbrella concept. It's a concept that regroups three fields. First of all, the concept of access to court proceedings by the public, physically or not. The idea that also we need access to the reasoning, the court reasoning. Yeah, I would call that the indirect open justice principle. And thirdly, the complementary open justice principle, the idea that you need access to publication of the judgments. So we have a huge concept, and a lot of times I see that it is handled as a secondary problematic. Actually, it's the essence, and I'm not the first one to say it. It's for 2 centuries. The doctrine says that open justice is at the center, at the essence of justice. Without open justice, we lose legitimacy. Where do I want to arrive very quickly? Is that in my perspective, a perspective of media law professor, it's that we had a statu quo for a long time between media and justice. The statu quo was fine in Europe. We avoid what we could say circus media with the impact of audiovisual. And we focus on specialist journalism. And the journalist will be the bridge between the public and the judges. It's nice, but it completely misunderstands the 3 last decades of media evolution. The fact is that in the digital society, audiovisual has lost every power. Journalism is in a huge economical crisis. So what do we do now? I believe that we need a radical shift of view, of a perspective on to save the legitimacy of judges. And to save this legitimacy, we need to reinstall at the heart of the problematic the concept of open justice, to open it to digital aspects. Just one example. The other day I've seen that the ECG, we're finished?
2 minutes.
Okay. The ECG has used, for example, YouTube, short video on YouTube to explain their judgment. It's incredible. It's really nice. I think it's just one aspect. We need to be more radical to open again the court proceeding to the public. I'm thinking, for example, web broadcasting. We had a lot of advance on web broadcasting with COVID. We need to use it again. We need to generalize it. I don't have time now to discuss with you the various European regulation on the case law, but we do have some legal basis. Thank you very much.
Oh, thank you. That was 9 minutes. Thank you. And very impressive. Not a single note to guide the speaker. Well done. Our third contributor is George Contis.
Thank you, Chair. My topic will be about the principle of the judge indicated by the law and the bond between this principle and the impartiality and the independence of the judges. It is a principle that it is provided also by the Greek Constitution at Article 8 and also in the common law at article, excuse me, I was talking in German previously, Article 109 in the Greek Civil Procedural Law. It means that a person should be judged only by a court that has been composed under neutral, general, and abstract criteria, and neutral criteria before the pending of each case. That means that through the pending of a case, the composition of a court should not be revoked or moderated. This principle addresses to 3 dimensions: the state, the courts, and the parties. First of all, should the state indicate or choose a judge under political or ideological criteria? Of course not. This is a straight violence of the principle. But in Greece, there is a continuous public dialogue about the issue that the Greek government chooses the leadership of the Supreme Courts under the proposal of the Ministry of Justice. So, until now, the presidents and the vice presidents of the Supreme Court of Greece are chosen by the Greek government. There is a continuous dialogue about this problematic. Secondly, can the law revoke the competence of a court in a retrospective way? There are both opinions, yes and no. If this revocation takes place under neutral and general criteria, this revocation is not against the principle of the judge indicated by the law. 30 years before, there was a dialogue about the fact of changing the competence of the chambers of the Supreme Administrative Court in Greece. The important thing is that the chamber number 5 was competent for great environmental issues and urban policies and has invalidated many related acts of the government. The majority declared that this was an unconstitutional choice, and of course there was a minority of the court that expressed the opposite opinion. On the other hand, the competence in Greece is appointed only by neutral criteria. For example, material competence has to do with the value of the dispute or of the defendant's domicile or of the establishment of a legal person. Why? Because this is the application of this principle in Greece. Secondly, judges, courts. Has the supervisor of a court the authority to divide the cases of this court according to the needs of the court? Is this a policy against the principle? If this division takes place under neutral criteria, and if this division serves the needs, the objective needs of the court, then it's not against this principle. Secondly, can a court deny its competence? No, the denial would be against the principle. Third, can a case be removed from a judge during the lis pendens? It depends on the needs. If we have an issue of death or illness or recusal, so there is a need to replace the judge with another person. This is not against the principle. At the last amendment of the civil procedure, we have two facts: the abolition of the courts of peace and the removal of their competence to the one-member district court of first instance, and if the judge does not issue a decision in a time space of 8 months after the hearing, the law that it begins to takes in power in 1st of January of 2006 says that this case will be removed from this judge and will be given to another one. The abolition of the courts of peace, it has taken place under neutral criteria. Just this competence is being removed from these courts to another court. I don't find a constitutional problem. But in the second case, the removal of the case because the delay of the issuing of a decision, for me, seems to be problematic. But there is no litigation about this issue because this is a very fresh law. Parties. Third, can the parties revoke the competence of the courts? First of all, we say no, but there are exceptions. For example, we have an agreement of extension of jurisdiction. Where does it happen? especially in civil matters where the parties have the authority to dispose the object of a dispute. For example, dispute that has a financial or a commercial character. Another issue, the parties have the possibility to submit a dispute under arbitration. This is the ability that the parties have, and this ability is not contrary to the principle of the lawful judgment. Another example, a party applies a lawsuit in a false way to a superior court. For example, not in the competent one-member district court, but the three-member district court. And the second court keeps the dispute and issues a decision. Is that problematic? No, because the superior court has at least the same guarantees as the minor court. So these are these examples that shows the expressions of this principle in the Greek civil procedure. The principle of the lawful judge secures the principle of impartiality and independence, and vice versa. An independent and impartial judge is secured when the principle of the lawful judge is applied. Thank you very much.
I think George was trying to get the prize for the shortest presentation. That was 8 minutes. So the next speaker has... Oh, goodness me, yes, we can. So we're going to have a change of order, if that is acceptable. And Martin Sabelli, who is in Argentina, is on next, so as to accommodate his later activities.
Thank you. I think I will win the prize for the shortest presentation,
Right.
because I have to be in the airport in about 20 minutes or miss my flight.
It's not a very
in fact, you can probably...
I just want you to know it's not a very
No.
generous prize.
No, it isn't. And yeah, and I appreciate the invitation. I appreciate the accommodation. And I will be very brief. I want to promote one idea here that I think, and it comes from my experience in the United States as a defense lawyer for many, many years. I was also president of the National Association of Criminal Defense Lawyers, which is an association of nearly 50,000 defense lawyers. And from that perspective, I was very focused on the disappearance, the extinction of jury trials in the United States, and at the same time involved in the establishment of jury trials in Argentina. And the reason that I focus on that is I think that when we speak about judicial independence, and particularly the legitimacy, not just of judges, but of the judiciary and of the judicial system, I think that we cannot neglect the importance of the transparency, and this is a value that must be put, as some of the speakers have already done, foremost, the transparency that the jury system brings. And I'm not referring to what was the original sort of spirit or ethos of the jury system, which was the elite jury, the jury of people who were considered elite in society. I'm thinking of the modern jury, which is democratic, based on a cross-section of the population, representative. And of course, I'm referring to countries where the jury exists. In Argentina, I'll be very, very brief because I think it's an interesting story that we don't have time even to do the Netflix trailer on this. But in Argentina, the framers of the Constitution at the beginning of the 19th century essentially copied the structure and the spirit of the United States Constitution, including the jury trial. And it was the judiciary that for the next 180 years did not allow juries to essentially, and I'm making this much more simple than it is, obviously, but jury trials, although they were in the original Constitution and in the original equivalent of the Declaration of Independence and in the original Constitution of 1853, the first real jury trial in Argentina was 2014, 160 years later. And I think that because of that, judicial independence in Argentina, and by the way, judicial independence in Argentina is very questioned, and therefore judicial legitimacy in Argentina is at an all-time low. Some studies have it at about 7 or 8%. Because of that, because of the absence of the jury, I believe that judicial independence has suffered, specifically because there's very little transparency and therefore a great deal of speculation and doubt about whether or not the judiciary is responding to the correct values, corrupt or not corrupt, and frankly, whether or not the judiciary works hard enough or not, because there isn't a window into that perception. So in the very little time that I have, and thank you again for accommodating me, I want to raise the importance of public participation, specifically through the jury trial, as a way to guarantee, afford some type of transparency into the system. This is, of course, has some different forms. There are mixed juries in some countries in Europe. I'm really talking about the classic jury, and the classic jury of lay jurors who, because of their direct participation, and again, not the elite jury, but the democratic modern jury, because of their direct participation in the process, can ensure that the values of the society are being lived out, are being realized in the criminal legal system or the civil legal system. And one final point. I think the jury is also, I wouldn't say an antidote. It is not a cure, but it is one factor that can help address something that one of the earlier speakers referred to, which is the problem with the media in the modern world, the distortion of an extremely biased media. And I'm not saying one side or the other, right or left, but it is very clear that that the media across countries, across the globe, has a very poor understanding of the way judicial systems work, and therefore the way that the media can publicize the workings of the judicial system contributes to a lack of legitimacy of the in the criminal and civil legal systems. And jury trials, to the extent that they can bring people into the system who can see how it works, see whether or not it works, and therefore explain to not only understand themselves, but explain to their communities how the system works and whether or not it works. Jury trials are a partial antidote, one strong factor, in my view, that can not only afford transparency, but begin to remedy some of the very serious problems that are caused by the distortion of biased media coverage. So I want to thank all of you for letting me come in with on the shortest presentation and interrupt the order of the panel. I'm going to have to say goodbye and leave because I've got to get to the airport. But thank you very much for this opportunity, and I apologize for having to drop off. I'm very interested in everything that you folks have been saying, and I'm sorry that I'm going to miss the rest of it.
Well,
Thank you.
Thank you very much, and safe travels. It was very
Thank
interesting.
you. Thank you.
Very interesting to have the jury introduced in relation to the independence of the judiciary. There's food for thought there, and perhaps I might just mention what some of you may already know. The British government is proposing to reduce by 50% the number of jury trials in criminal cases in the English criminal courts. At the moment, it seems to be meeting some opposition from the criminal bar, from the criminal judges, within Parliament, within the media, and pretty well everywhere else. and it probably won't get. Yeah.
Yeah,
Don't miss your
let me
plane.
say this. No, I won't miss my plane, but I'll say this.
Yes.
You know, what you say is very interesting, and Scotland has weathered a storm as well, in which there was an effort to remove sexual abuse, sexual assault cases from jury trials under the theory that judges are more impartial. And that's something that this panel, I think, should put on the table. The notion that one person today, with what we know about modern psychology and neurology, prejudices, implicit biases that come from who you are, what gender you are, what racial background you are, what socioeconomic class you are. The notion that a person or three people, a panel of judges, can be more impartial than 12 separate people who are judges of facts. Jurors are judges of fact, is something that we need to question. From the perspective of modern neurology, I think it's very different, neuroscience, rather, it's very difficult to posit that judges can be nearly as impartial as 12 different people. Of course, you know, if you've got a terrible jury selection, or in the UK, you don't have a jury selection, that is a different matter. But I think jurors as judges is something that this panel ought to consider. So I'm now in danger of missing my plane. Thank you for letting me interrupt you, and I appreciate the time.
Thank you very much.
Thank you.
Thank you. Right, we are now moving on. Andrea Danusa from Switzerland.
Thank you for the invitation. I'm greeting all my old colleagues, and myself, I'm not an academic. I was all my life a barrister at the Bar of Zurich, and specialized.
You were the General Secretary of JIWP.
Also.
For many years.
Yes. Okay. Let's go into. I will talk you about political parties and the appointment of judges to the Federal Supreme Court in Switzerland. The current constitutional regulation of appointment of judges to the Federal Supreme Court is the following. Federal Assembly elects the judges of the Federal Supreme Court. What is Federal Assembly is just the two chambers of the Federal Parliament. The term of office of judges is 6 years. General elections to the Federal Supreme Court are held every 6 years. The Federal Supreme Court consists of 38 full-time judges. What immediately strikes the mindful observer of Eli Mount Scopus standards about this legal setting is the very short tenure of judges, the fact that they must face re-election every 6 years, and the direct connection of the electoral body with politics, their politicians. Worse, underneath this constitutional setting exists the following soft law or traditional lived until today in Switzerland. Parliament unofficially allocates judgeships according to party proportional representation, a distribution key based on the strength of the parties represented in Parliament. We have every 4 years we have election of the Federal Parliament, so the actual judges always are a little bit from a former period. Giuliano Racioppi, an administrative judge of Canton Grisons, has done an excellent study about this soft law. He calls this practice Europe-wide and probably unique in the world, and to be in conflict with all international standards of judicial independence. The Venice Commission of the Council of Europe stated already in 2006 quote, appointments of ordinary judges are not appropriate subject for a vote by Parliament because the danger that political considerations prevail over the objective merits of a candidate cannot be excluded, unquote. Transparency International made pertinent observations already in its 2013 overview, quote, in economic terms, therefore, judges in Switzerland must de facto buy their judgeship from a political party cartel. Action is needed to legislatively prohibit mandate taxes as a step toward improved independence. Sorry, I missed one paragraph here. Not only the direct election of the judges, but that they must pay a mandate tax. The judges, if then elected, must pay an annual mandate tax porting them. This is called party mandate tax. Depending on the party, it is between Swiss francs 3,000, the rich parties, and 26,000 for the poor parties, let's say left-wing parties, on a salary of 356,000 per year. So now I have already quoted the Venice Commission and the international standard. Also Greco in 2019, the group of states against corruption concluded that there was still a need for action on the independence of judges, the danger that judges could be voted out of office for political reasons was still present, and the maintenance of mandate tax to the political parties still violated the principle of judicial independence. There were many examples of attempts of political influence. Probably the most blatant case occurred in September 2020. Supreme Court Judge Donsala, who was Supreme Court Judge since 2006, was no longer nominated for election by his party, the Swiss People's Party. However, he was nominated for re-election by the Parliamentary Judicial Commission. The rift between the party and Supreme Court Judge Donsala stems from a federal Supreme Court ruling that allowed the Federal Tax Administration to transfer information of some 40,000 UBS clients to France. This ruling was in 2019 and came down to a 3-2 vote, with Donsala voting in favor for the data transfer. I quote Donsala, who said, the party had been putting him under and other judges under pressure for years, that it was trying to put the judiciary in a stranglehold. This was no longer acceptable to him. He said, I quote, "The problem goes beyond me personally. The independence of the judiciary as a whole is at stake," unquote. In May 2018, Swiss citizen Adrian Gasser proposed the following amendment to the constitutional provisions on the election of judges. He proposed, the term of office of judges ends 5 years after reaching the ordinary retirement age, at the age of 70. The judges shall be selected by lot. Admission to the lottery shall be decided by a commission of experts whose members shall be elected for a single term of 12 years. After a restrained public debate, Swiss people rejected this initiative in a referendum of November 21 by 68 to 32%. Why this? There is another problem underneath. All the parties in parliament have every year substantive income out of this mandate tax, because besides the 33 judges of the Federal Supreme Court, there are 72 federal judges of the Federal Administrative Court and 60 federal judges at the Federal Criminal Court, who are also elected in the same way as explained before. Particularly for all the small parties, this income is crucial and substantive part of their budget. In Switzerland, there is no funding of political activity by public means. So, these are my explanations of the Swiss system. Thank you.
Another panelist, well within the time limit. And finally, Professor Mikhail Antonov from St. Petersburg.
Thank you so much. It's a pleasure to be here and to be a part of this great conference, and I'm very thankful to Professor Kyriakidis, to Professor Chitrit, and to all the organizers for staging this brilliant event, during which I have learned a lot of things from different jurisdictions. And I'm also happy that the organizers had wisdom to place me into this section that concerns ethical issues about judicial independence. It is indeed the point I do not stop asking myself about what I can do, what I can improve in my country concerning these issues. The situation in Russia, as you know, seems to be rather hopeless in terms of judicial independence and in many other respects. But it's not the reason to lose heart. In Russian we say, don't leave hands hanging without action. And I ask myself what to do. In my speech, I will try to dwell about judicial independence in internal aspect. You know, certainly this Kantian or Immanuel Kant distinction between external and internal freedom, which allows us to put external freedom as external judicial freedom, independence as something that comprises a set of rules of institutions that shield judges from political and other influences and interferences. This independence usually goes hand in hand with general political situation in the given country. And normally, as Professor Chitrit has wisely noted today, it reflects the level of liberal democracy and of the rule of law in this country. I said that there is little to say about this aspect of this external aspect of judicial independence in Russia. That's why I will try to focus what can be done for promoting by the intellectuals, me as a law professor at the university. What can I and my colleagues can do to improve? Well, we cannot improve external aspects because it's in the field of political decisions. But what we can do in terms of internal independence, internal freedom. And I have some thought on this, and I will share it with you. Political scholars usually portray judicial judicial decision-making in authoritarian countries as largely or wholly controlled or guided by the political power. This vision makes sense in certain respects, but I believe that it is generally oversimplified. From the millions of cases that are decided at Russian courts annually, only very few concern so-called high-profile cases, cases in which political interest plays a significant role, and where judges are actually exposed to political pressure. However, from this we cannot conclude that in all other cases, except these high-profile cases, judges are free. And here we face what in Russia we call internal censorship, внутренняя цензура. It implies that every judge is expected, consciously or unconsciously, to ask him or herself, dealing with this or that case, whether there be any political interest and the case shall be decided so specifically, or this is a normal everyday case in which the law can be applied. This is what I call internal censorship. Nowadays we have no longer so-called telephone justice or telephone law, for which Soviet law was famous. Nowadays judges have no opportunity to call partcom, a party committee, and ask whether this is high-profile cases or not, and what should I do. Normally, judges and the presidents of courts, who can sometimes consult judges, have no clear guidelines to distinguish politically motivated and everyday cases. There are quite many judges among my former students, and from time to time I exchange with them on their career, on what is going on in courts, also in this respect, and they say that normally they almost never fail to discern a politically relevant case and well, to know how to decide it, but they quite often err in determining a high-profile case among the ordinary, everyday cases. For example, there's a lot of cases, and you can read in Russian media, where a judge, if there is a simple debt collection case, but in this case is involved a state company, I don't know, Rosneft or Sberbank, judges think that they should decide in favor of the state. What the reason? The reason is, very shortly, I believe that I have already spoken about this at previous occasions, that we have still the common theory of law, like Austin and Bentham. So there's a sovereign, and the sovereign determines what law is, and judges are servants. So we have now this culture of intellectual independence, of which Professor Streetrate said, mentioning the English judges who don't consider themselves to be servants of the Queen or the King. We don't have this intellectual culture, and that's why quite often judges make mistakes on determining such simple cases as high-profile cases. And as a result, for example, general procuracy files a lawsuit in the court, so judges simply stamp it, and that's it. But then in higher instances, these decisions are quite often overturned, and it turns out that there is no political interest, or this political interest is on the second. On the second row. 2 minutes? 2 minutes, yes. So the problem is that judges are not always trained in critical thinking, a kind of legal argumentation of which Professor Zoller has mentioned about Einheitsjuristenkultur in Germany. So we have this paradigm of judges as servants of the sovereign will, and it doesn't work actually. Well, even if even in authoritarian countries, judges are relatively rarely exposed to political influences. If you calculate the high-profile cases, which are always few, and the general lot of everyday cases, certainly there are cases in which political influence is exerted. In such tragic cases, judges can either pragmatically choose to follow the political lead or to have the courage to stand against this influence and to face negative consequences for asserting their freedom. This also happens from time to time, even if not so often. Still, these tragic cases are rare. In many situations, judges simply figure out imaginary political influences, imaginary political interests, state interests, where it actually lacks. In the situation where we can not unfortunately change or improve the authoritarian regimes and to secure the external independence of judges. We intellectuals, can try to promote the culture of legal argumentation, of critical legal thinking, and to improve as far as it's possible the situation with the internal independence of judges. That's it. I'm finished.
Only if you're finished. Have you finished?
Yes.
Oh, thank you. What I was trying to do was turn off the clock. I didn't want that to be interrupted by a noisy phone. I thank you for that thoughtful and, if I may say so, brave contribution. Do we have some time? We do, and we have a question from the former Chief Justice.
Thank you. Can I take up something that Professor Juglot mentioned, which never occurred to me before? How accountability, which is also an element of the independence of the judiciary, or can be achieved through publicity. And that ties up with what Mr. Sabelli said, the publicity and the participation of jurors, but also with the publication of the reasons in a judgment. Now, my problem is that in Malta, as time goes by, these judgments are becoming more and more unintelligible and less user-friendly to the clients, to the ordinary man or two people who have sought a remedy in court. I remember when I was a law student many years ago, our hero was, and I'm sure the chair will remember, Lord Denning. And the way that he wrote with clarity, simplicity, and in a storytelling way, instead of the dense formal legalese used in the judgments. When I was Chief Justice, I tried to persuade my colleagues to do this, but unfortunately, the combined effect of the assistance of judicial assistants like law clerks, plus the use of cut and paste from judgments which are being quoted and so on, has had the opposite effect. Nowadays, judgments, especially this affects both when there's a panel of 3 judges, because we don't have dissenting opinions, but especially at first instance, the judgments are more unintelligible than they were when they were being delivered in Italian before 1933. And this is something that really, I get people coming, showing me a judgment, trying to for me to explain the judgment to them. Sometimes I don't even understand the judgment myself. It's so dense and sometimes contradictory. I think that is something which runs counter to accountability and to the trust that people should have. I know that Lord Wolf tried this simplification and to a very large extent succeeded in the United, or in England at least. But in my country, this is a problem. The complicated way in which judgments are formulated. Thank you.
Yes.
Thank you very much for this interesting panel. I have two comments. One is about the, unfortunately, I hope the speaker reached the flight, but it's about jury trial. And I think this is very interesting question for different countries. And of course, it is a little bit a part also of judges who are elected in kind of different societies. Poland had jury also in the part of Poland where the Austrian procedure was applicable and French procedure in the criminal cases before the war. And it was cancelled because of evidently bias-based ruling in huge conflict on ethnicity and other issues like this. And we have also here in the situation where we have very deep political conflict and clash, the danger that the jury will decide in the way which is somehow politically driven is in this society is quite high. So this is, it won't be, for example, the solution for example, for Poland to have a jury trial. It will be a disaster. And of course, there is an issue as we were talking about the YouTube display of court's reasoning. It's important. We have to find a way to communicate. And in France, you have this experience. You have also the summary. Conseil d'État publishes the summary of the judgment, which are extremely important, probably. And this is a very good way of making such kind of communication. But I'm a little bit afraid because the social media are very dangerous, because when we have this facts and no facts are mixed up. And there is a question whether if we start really publishing TikTok judgments, whether we enter also this area where the facts and non-facts are mixed up, and it could be a very high cost also for judiciary. And I'm not sure whether the way to enter the world of TikTok culture by courts is the best way to be present in the public.
Yes, Professor.
Very briefly.
Just to follow up, I don't think that decision is in at least some jurisdictions. In some jurisdictions, judges can still think about it. In other jurisdictions, it's already there. So you can say, well, I don't want to be there, but then others are, so there's no vacuum. In which case, you might be proactive. And I agree with you, the judges have to know what they're doing. And usually, and this we heard from Natasha, judges are not supposed to be good in this. They're supposed to be good judges, not good YouTubers. And you don't want to raise judges to become good YouTubers because there's a conflict of the ethics and the entire role morality here. How do judges use the media? We have a terrible experience in Israel. They tried to do it, they failed, but it doesn't mean that we shouldn't experiment with it. I do want to challenge the notion of open justice if we come here. And the reason, and there are two challenges here that we have to confront. One is the conclusion from last conference. It adds a lot of resources because when you open, and the more you open, the more people may take advantage of this and then delay, and you want to hear this, and this other party says, well, I actually have something to say. And the other party has, so you have to, there's always a tension between this and rules of procedure to say, okay, who has standing, who can be heard, and then there are always issues surrounding that. The other component is we've heard from our Ukrainian colleague, judges can be hunted under the name of open justice. What about your secret lover? What do you like to eat at lunch? And all those issues under the name of transparency. we want to enter your bedroom or whatever room, you know, I don't want to, yeah, whatever room you want, because each, and apparently judges have also love lives and all that. Apparently, you know, what can you do? And then you can see that it can also be captured. So it works to the extent polarization doesn't capture it. And polarization may capture this as well. And we've seen that happening in some jurisdictions.
Thank you very much. Yes, do you want to come back on that?
If it's possible, I would like just a little reply to the three comments, if possible, together. For the first one, I would just say that I'm kind of speechless, because it's exactly what I'm talking about all the time. Lord Dunning, of course, is and should be always an example. I have in mind this very famous decision about contract law, where he was talking about the bleak winter of contract, and he was talking about the big man and the small man. And I'm always talking to my students, you see, that is the law, as it should be. It's not using huge, complicated Greek sentences, but it's talking about the big man and the small man. And yes, we need to make a pedagogy, I can't say it. Thank you very much, effort. We have lost something in the last decades at this point. So that, for the first comment, I really thank you for that. The second one, I really understand the fear of the TikTok judgment. It's completely understandable. But TikTok is here. So either we take the place and we can fight disinformation, fake news, and mistrust at equal, or we just let the place to the other side, the side of misinformation. So it's a political decision. I completely understand. But my opinion personally is that we should not let the place to misinformation. We should fight as possible. And we arrive to the third part, the part of transparency. Of course, in a democratic society, no transparency should be absolute. Even open justice knows some limits. GDPR for the European, of course, but also protection of innocence, protection of juveniles, and even commercial aspect as confidential information. We should protect them as we should protect also the judge. Nonetheless, there is some way, a middle way, I believe. A middle way to protect that should be protected and to make more efforts. We are very, very far behind in terms of transparency. Today, there are nobody in the courtrooms. We have no fundamental theoretical protection of the concept of open justice. It's indirect from Article 6 and 10 of the European Convention. We don't have in the front line the open justice as a main preoccupation. We need to change that. It's just an opinion, of course. Thank you very much.
Have we got time for one more? Because there is one more. Yes? Yes, go ahead. There's a microphone here. If no, shout.
It's a pity that our colleague has gone to the airport because the jury is also a fascinating topic. And I wanted just to tell you something about the experience in Belgium. According to our constitution, we have jury trial for press cases, so freedom of speech cases, for political crimes, and also for severe crimes. The original idea in the constitution was only the first two, but then for serious crimes, the jury was also added. Now, in practice, for serious crimes, it works more or less. I've never been in favor of the jury for serious crimes, but I've always been very much in favor for the jury for press, speech, freedom of speech, and political crimes, because that is where you need maybe more than professional judges, that you need a little bit more representativity. And what we see is that the courts have, for 200 years, well, nearly 195 years, have tried to get rid of the jury precisely in those two cases. Not for serious crimes. They were always install a jury. But if someone invokes the right to a jury because he says this is a free press case, freedom of speech case, or this is a political crime, they will find any kind of excuse not to give you a jury. And I've never been a criminal lawyer in my life except in political cases. And at some point in Belgium, the Constitutional Court declared that a certain aspect of our electoral law was unconstitutional. But there was no political majority to change it before the next constitution. So we organized a deliberate action of civil disobedience that people would not contribute to the organization of the elections, and they were all persecuted, evidently. And so this was clearly a political crime in the sense of the constitution, and we've never got a jury. We won most of the cases because of prescription, because of the short prescription delays, but we never got a jury. I've published this whole story if someone is interested. And freedom of speech, it changes a little bit. On the one hand, the court has been a little bit more wide in accepting the notion, the constitutional notion of freedom of speech, because in the past, for example, it had to be written. If it was on the internet, then it was not covered by the right to a jury. That has been opened up. On the other hand, the politicians have changed the constitution in a very strange way, saying that if the speech is racist, you're not entitled to a jury. If it's criminal in any other way, you are entitled to a jury, which is in itself, well, a constitutional provision cannot be unconstitutional in my eyes, but at least it can be an absurd distinction.
Thank you. Well, I think we'll draw to a close there. On your behalf, may I thank the panel very much, not only for their contributions, but for being so well behaved. Thank you.